01-2026-CF-854A, State of Florida versus Christian David Vargas. Mr. Shafton, good afternoon.
Good afternoon, Your Honor.
Your motion to quash the capias, reinstate previously set bond.
Correct, Your Honor.
Right.
And I do have in the audience Mr. Rodney Long, who is the president of the bail bonding agency that bonded Mr. Vargas out originally, and also Christian Vargas and his mother. They're all in the audience. I don't know, would you want Mr. Vargas to be present next to me, or?
Is he, they brought him over, I assume?
He's not in custody.
Oh, he's not
in the audience.
Okay. Yeah, why don't you come on up then, if you would, sir. Have they not executed the capias then?
Your Honor, it has not been executed. Mr. Vargas is on ankle bracelet monitor and has been present the entire time, but it has not been executed for whatever reason.
To clarify, there are 3 different cases pending. He had already posted bond in 01-2023 CF-2251A and 2023 CF-2250A. Then this 3rd case came in, that being the 2026 case. The warrant was issued. It was served on him, and I believe that was $200,000. We then had an arraignment, and Mr. Vargas failed to appear at the arraignment. At that time, the court revoked his bond, and I believe set it as a $500,000 bond.
Okay, that's what occurred last week. All right.
But he has not been picked up on that revocation.
You said there's 2 other cases?
That's correct.
What year are they from?
2023.
Okay.
And Your Honor, first, Ms. LaBianca is correct about the procedural history of the case. You may recall when we have the case managements, Mr. Vargas's presence was excused a number of times when we appeared before Your Honor for case management. Both the state and myself, on behalf of Mr. Vargas, had indicated to the court that there was this 3rd case out there. Just for clarification purposes, this is not a new case. It's a case that dates back to, I believe, the same.
It's not a new set of facts. The
Correct.
facts happened contemporaneously with the 2023 cases. We just didn't get the case until 2026, the formal charges.
All right.
Right. So it's been out there, and I on a monthly basis, we kind of addressed this with the court. And what happened, in fairness, is when I got notified that that the case may be filed, I met with the family, and we, of course, I advised them, as I did with the other, that if they retained my office, we would be filing paperwork that would obviate Christian's need to appear for the arraignment, and things would continue on. It would just be another case. And so what happened was I went out of town, Mr. Vargas, or Mr. Vega rather, went out of town, and in the meantime, the notice came through for an arraignment. And that's what he failed to appear for, was the arraignment on the brand new case. And again, it was just oversight. As I mentioned previously, Mr. Vargas is on ankle bracelet monitor, and he has had court services report to the court, and he's never had a violation at all, and never had any issue with the conditions of his release. And of course, his bondsman is present and can also attest to that. The other thing I wanted to mention to the court, in addition to what I've just mentioned, is that the 18th he went to the university and had a follow-up. It was an oversight that he did not make his arraignment. Otherwise, we would have filed paperwork and covered his arraignment. He's been in constant contact with my office and through the court system, and as indicated, he's been on ankle bracelet monitor without fail. So I'd ask that the court quash the capias, reinstate the bond, so that we can go ahead and process this new case. As I mentioned, I think at one of the case managements, ultimately we may be approaching the court about consolidating it. We're obviously working toward a global resolution with the state, and we were just waiting for the new case to come about. And now that it's here, we would continue our negotiations with the state once we complete the necessary depots on the new case.
Are the other cases L&Ls as well?
They are.
They are, Your Honor.
Different, it's a different victim in each case.
Different victims, so there are 3 different victims.
Correct.
All right. Let me ask you this. I was the one who signed the original capias for $250,000. How did he end up with an ankle monitor on? I never ordered that as part of them.
I think the ankle monitor was part of the original,
One of the other cases?
the 2023
Okay.
cases.
That's correct, Your Honor.
Okay, that's, could very well be. All right. All right, Ms. LaPianca, what's the state's position?
To be perfectly frank, I suspected at the time of the arraignment that there was a misunderstanding in that Mr. Schaffnet had not filed a notice of appearance in the new case, but he and I had discussed it several times. So I knew that he was aware of it, and I was anticipating a notice of appearance, but he had not filed one. As a result, I suspect he was not notified of that arraignment date. The defendant, however, was notified of it and failed to appear. It is his responsibility to be in touch with counsel. Beyond that, the state does defer. If the court is considering quashing the capias, I would ask that Mr. Vargas be ordered to turn over his passport and that he be ordered not to leave the continental United States. Over the time that these cases have been pending, I've been told on several occasions that there's been a lot of travel to and from various places such as Puerto Rico and some Latin American countries, which has raised some concerns about fleeing. So that would be the only change that I would request if the court is inclined to quash the capias.
And Your Honor, in response, the family has been traveling, Mr. Christian has not, and of course the ankle bracelet monitor would confirm that. He does have a passport. He would certainly be willing to surrender it per the state's request and be restricted in travel until the case is over.
Where are we at on the other cases, 2023? So.
The other cases are currently set for June 1st case management.
How close are we to trial on any of these?
I would say not too far off. We've done the vast majority of the depositions. I don't know if there are any additional depositions that you're planning on setting.
Victims? Your Honor, per the policy of the state, we've tried to not depose certain individuals to make sure that we can approach the state with an offer. Like I said, it had been my intention to consolidate these cases simply because I think at the end of the day, the state will probably seek to admit 404 evidence of the others, and so it to me makes sense in the interest of judicial economy to have them consolidated either as part of a global plea offer or as part of a trial if need be.
I would be seeking to bring them in as Williams rule of each other. I don't think that I have legal standing to consolidate the cases without the consent of the defense because they are separate victims, separate
Right.
incidences, but I don't object to having them all resolved together and to be frank, to minimize the court costs. I don't think it's necessary to handle them as 3 separate cases if we're all in agreement, particularly if there's a plea. It's just I can't do that without being subject to a motion to sever.
Sure. And I'd agree with Ms. LaPianca's representations to the court. I think if the defendant consents to it because these are not related temporally in time and they're separate victims, that it would require the defendant's consent and an active request for them to be consolidated.
I would agree. Absent of Williams rule notice, that would probably certainly be the case. What does he score to? Have you got a score sheet? Assuming that he was convicted as charged in all 3 of these?
And while Ms. LaPianca is looking for that, the other thing I failed to mention is because of his status, the state had to go through the hoops in terms of the direct file. He's now an adult, but these cases, as indicated, predate his age of majority.
How old are you now, sir?
22, sorry.
22?
22 years, sorry.
He was 17 at the time.
Okay.
All three cases, he is scoring 180 right, 180 months. Apologize.
Anything else, Mr. Chapman, from your
Your Honor,
staff?
if the court has any additional questions, I'll be glad to answer them. Like I said, I think it, unfortunately, because of the way it ended up being filed, direct filed, and all of that, his dad went out of town, I went out of town, and again, I don't disagree the terms of the responsibility, but it was just literally one of those things where the time slipped away and the arraignment notice got sent out, and again, it was not in any way intended by Christian to disrespect the court or to not appear. It's just a snafu concerning the filing of the notice of appearance in connection with the new case.
How far are we away from trial, at least on one case, if they were not consolidated?
I would say, assuming Mr. Schaffner doesn't have availability issues, which he typically does because he has a very busy trial schedule, I would say 1 to 2 months.
So it's something we might be able to set for trial in August, July or August?
Mr. Schaffner was just telling me about trials that he has coming
Right.
up.
August, yes, I have a trial in front of Judge McCourt down in Marion County at the end of July, but August is, and I do have a case with Judge Ferrero, but it would require a hearing on a Daubert issue, and I don't see that case going before August.
I see, okay, well, that's helpful. All right, I think what I'm gonna do here, I'm bothered, number one, by not only the fact that he didn't appear, I understand it might have been an administrative snafu, but I'm bothered by the pace of the cases, where they're at, the age of some of the cases. I understand this was filed later, but I think what I'm gonna do here, I'm gonna leave the capias in effect. I'm gonna leave the bond at $500,000. What happens with the estriture of the other bond, Mr. Long? That's pretty much between you and the clerk. You may have legal grounds to have that set aside. They routinely do that, I know. But I'm gonna leave this capias in effect, so I'm gonna take him into custody right now on the capias. If you'd prepare an order denying the motion to quash.
Yes, Your Honor.
Any what? Okay. I guess they need the order right now, so they can book in. So you need a copy of the capias. Those will remain, and I'd like to put this one on for June first also, so the other two. That was $500,000, right?
gonna go to the portal where Ms. Courtney would have to print it out. I don't have
Can
a,
you send it here to the clerk? She's not here today.
so it's not gonna look right, is the problem?
It's probably the only alternative I have, is Alex is not here, and they won't book him without that order.
Let's see if I have one in my folder.
Oh, okay, thank you. I don't understand any of that sound. Oh, so, I'll take this to KPS. Yes. Okay, good. Then we know.
I sent you before again, we covered Yes.
All right, looks like we have everyone here for the motion to suppress.
Rob, that's all I have. I'm at the excuse.
Mr. Chapman, have a nice afternoon, sir. This is